The particulars are that being a public officer, he breached the trust placed in him by facilitating payment of public funds for compensation of land alleged to be public land. The second accused person, Salome Ludenyi Munubi, similarly faces the charge of conspiracy to commit an offense of corruption, the particulars being same as I have stated on count 1 above. On count 3, she is charged with abuse of office, the particulars being that on diverse dates within the same period, being a public officer at the National Land Commission, she improperly used her office to confer a benefit by facilitating compensation for the said parcels. In the alternative, she's charged with breach of trust, the particulars being that the second accused being a public officer, she breached the trust placed in her by facilitating payment of public funds for compensation of the said parcels. The third accused person, Tom Aziz Chavangi, is also charged with conspiracy, and the particulars are the same as I have stated in count 1. He is also charged with abuse of office, the particulars being that on diverse dates, being the chief executive officer of the National Land Commission, he improperly used his office to facilitate payment of compensation for land alleged to be public land. In the alternative, he is charged with breach of trust, the particulars being that the third accused being a public officer, he breached trust by facilitating the said payments. The fourth accused person, Francis Karemi Mogo, is also charged jointly with the others in count 1 for conspiracy to commit an offense, and the particulars are the same as stated. He's also charged with abuse of office, particulars being that on diverse dates, being a director of finance and administration at the National Land Commission, he improperly used his office to authorize or facilitate payment of compensation for the said parcels. In the alternative, he is charged with breach of trust, particulars being that he breached trust by facilitating payment of public funds for the said parcels. The fifth to eighth accused persons, and that is Atanas Karaoke Minor, Victor Wahome Karaoke, Elijah Mwenda Nyamu, and John Mwangi. Sorry, and just a minute. Of unlawful disposal of public property, contrary to Section 45, subsection 1b, as read with Section 48 of ASECA, the particulars being that between January 2009 and December 2016, within Nairobi City County, being public officers and or surveyors, they unlawfully facilitated allocation, survey, or registration of LR numbers 9084 to 9088, thereby disposing of public property. In the alternative, they are charged with the legal principles. As a trial court, this court is bound to analyze the totality of the evidence, identify the issues arising, evaluate the credibility and weight of the witnesses, and make findings grounded in law. The duty to evaluate evidence is substantive and not ornamental. Under Sections 107, 108, and 109 of the Evidence Act, the burden of proof lies on the prosecution. In criminal cases, that burden never shifts, save in limited statutory exceptions not applicable here. The standard of proof beyond reasonable doubt was laid down in the classic case of Wilmington versus DPP, which remains applicable in Kenya. Further in Kenya, the Court of Appeal in Sawe versus Republic reaffirmed that suspicion, however strong, cannot found a conviction. The court is also guided by the constitutional guarantee of fair trial and Article 50 of the Constitution of Kenya 2020. For the offenses under ASECA, especially sections 45 and 46, the prosecution was required to prove the constituent elements of each offense, including, where relevant, the existence of public property, improper conferment of a benefit, unlawful disposal or abuse of office together with the necessary factual nexus to each accused person. On the land question, the court must begin with the Constitution and the land statutes. Public land is defined by Article 62 of the Constitution. It is not proved by mere assertion. It must be shown to have vested in the national or county government or in a public body through law, reservation, setting apart, acquisition, or another lawful mode recognized by the Constitution and statute. It is now trite that a planning document is not a title document. In the case of Kurunzi Island Development Limited and two others versus County Council of Kwale, the Court of Appeal emphasized that a registered proprietor acquires an indefeasible title only where the allocation itself was legal, proper, and regular. The same decision underscores that land status must be demonstrated through lawful processes, not merely through administrative designation. The law is equally clear that land reserved for public purpose is not available for alienation to private individuals. In the case of African Line Transport Company Limited versus AG, the High Court held that once government land is not available for allocation, allocation is purportedly allocated, such allocation is worthless. The same line of reasoning has repeatedly been cited with approval in later Kenyan decisions. Conversely, where land has been lawfully allocated and title has issued, the title enjoys statutory protection unless impeached on the grounds recognized by law. The Court of Appeal in Athi Highway Developers Limited versus West End Butchery Limited and 6 others restated that indefeasibility of title does not protect a fraudulent or fake title, but the converse is equally true. One cannot defeat title by mere suspicion or administrative assertion unsupported by lawful proof. It follows that in a case such as the present one, the court must ask 4 questions. Number 1, was the land proved to be public land? Number 2, if it was it shown that it was not available for private allocation? Number 3, if titles existed, were they shown to have been lawfully impeached? Number 4, if none of those matters was proved, can criminal liability safely be imposed on public officers and private entities who acted on the footing that titles existed? The prosecution evidence. PW1 was a principal, that is Timothy Waia Mwangi was a principal planner from the Ministry of Lands. His evidence related to the planning status of the area and the existence of planning documents, including the relevant part development plan. The court accepts that PW1 was a competent witness on planning matters. However, planning evidence is not title evidence. A part development plan may show intended land use, zoning, or development proposal. It does not, without more, establish proprietary ownership. The prosecution sought to use the planning material to suggest that the land fell within railway land. That inference was not sustainable in law or in fact. A planning designation does not by itself vest land in a public body. The court adopts the legal distinction recognized in Kenyan jurisprudence that planning status and title are not synonymous. I therefore find that PW1 proved planning context only. He did not prove that the suit parcels belonged to Kenya Railways Corporation or constituted public land. PW2, Weldon Maritin, is a surveyor, later described as Director of Surveys, was one of the prosecution key technical witnesses. His evidence bore on the survey position of the parcels and the relationship to the railway reserve. The court has considered his evidence alongside the map overlays and survey exhibits. The overlay on FR 12/102 places the parcels 9084 to 9088 adjacent to a railway reserve corridor rather than conclusively within it. The same pattern emerges from the old railway reserve overlay and the 1956 and 1957 planning map overlays. A survey witness is best placed to speak to location and boundaries. Yet the material before the court does not show a conclusive technical placement of the suit parcels wholly within a railway reserve. At most, the evidence shows proximity to railway land. Proximity is not ownership. Adjacency is not reservation. PW2's evidence, therefore, did not conclusively establish public ownership. PW3, Abubakar Kistilo, was a cartographer from the Ministry of Lands. He appears to have participated in preparation or interpretation of the relevant map material. His evidence was technical and explanatory. It could clarify what maps depicted. It could not create title where no title document existed. The court treats his testimony as contextual. It did not prove that the land vested in Kenya Railways. PW4, Benson Limo Longe Lenyang. His evidence must be understood within the broader prosecution attempt to establish that the suit parcels were public land and that any compensation paid in respect thereof was therefore unlawful. PW4's testimony was primarily technical, documentary in nature. He testified as an officer conversant with records related to planning, survey or land documentation, and was called to shed light on the status and the authenticity of documents relating to the suit parcels. He explained the existence and handling of certain official documents within government systems, including planning and or survey-related records, and the process through which such documents are generated, authenticated, and relied upon in determining land status. His evidence appears to have been directed at supporting the prosecution theory that the suit parcels fell within land that was not available for allocation. However, a careful evaluation of PW4's testimony reveals its evidential limits. First, PW4 did not produce any primary instrument of title demonstrating that LR 1984 to 1988 were vested in Kenya Railways Corporation. He did not produce a gazette notice of reservation or a vesting order or any acquisition record showing that the parcels were public land. His evidence was therefore not probative of ownership in the strict legal sense. Secondly, PW4 spoke to the existence of authenticity or of certain records. Such records, whether planning documents, survey references, or internal correspondence, do not, in law, constitute proof of ownership, as was emphasized in Funzi Island Development Limited versus County Council of Kwale and two others. Ownership of land must be traced through lawful allocation or vesting, not inferred from administrative or planning records. Thirdly, PW4's evidence did not resolve the critical evidential gap that runs through the prosecution case. It did not answer the fundamental question, who owned the land? Without that answer, the prosecution case cannot stand. In evidential terms, PW4 must therefore be categorized as a supporting technical witness whose testimony assisted the court in understanding the documentary and administrative context of the suit parcels. However, his evidence did not advance the prosecution case on the decisive issue of ownership. Accordingly, while PW4's testimony is relevant in understanding the documentary background of the case, it does not establish that the suit parcels were public land and cannot, either alone or in conjunction with other similar evidence, sustain the charges against the accused persons. PW5, Harrison Felix Jumba, a retired chief cartographer in the Survey of Kenya. His evidence concerned correspondence seeking confirmation of the authenticity of allotment letters and the PDP concerning the suit parcels. The evidence is important for what it reveals about institutional uncertainty. The survey office itself did not treat the parcels as obviously and indisputably public land. It sought confirmation from other institutions. That conduct is inconsistent with the prosecution thesis that the land was plainly railway reserve land. PW5 therefore proved process and administrative verification. He did not prove public ownership. PW6, evidence centered on planning confirmation letter that led, and on a planning confirmation letter, which later became contentious as to authorship or authenticity. There was tension in the record between testimony said to disown the document and later forensic evidence said to support ownership. Where a key document is itself disputed in a criminal trial, the court must be slow to assign it decisive weight. That caution is especially necessary where the document relied upon to prove a foundational fact, such as land status. I therefore find that PW6 evidence did not resolve the ownership question in favor of the prosecution. PW7 was the Deputy Director Legal Affairs at NLC and Secretary to the Review of Grants and Dispositions of Public Land Committee at NLC. He was a central prosecution witness, that is Brian Nicola Dungo, because he linked the suit parcels to the committee minutes and a report concluding that the parcels were not available for allocation and were ineligible for compensation. His evidence at first sight was potentially powerful. It suggested that the NLC had already determined that the parcels were not payable and should be revoked. But on closer scrutiny, the probative force of that evidence diminished considerably. The report underpinning the review process was unsigned. The record refers to an underlying survey report that was never produced despite adjournments and opportunity. The prosecution did not demonstrate that the committee's recommendation was translated into a legally operative step before the Chief Land Registrar, as would be expected if revocation were being effectively implemented. The defense evidence also raised the serious point that the committee purported to revoke titles before they had crystallized in the form later relied upon. The prosecution did not adequately dispel that difficulty. The court therefore finds that PW7 proved internal institutional concern and internal committee deliberation. He did not prove beyond reasonable doubt that the land was public or that the parcels had been lawfully and effectively invalidated before compensation. PW8, Abigail Mukolwe Bagaya, was the deputy chair of the NLC and figured prominently in the committee structure. Her evidence explained internal NLC processes and committee deliberations. The evidence was relevant but not conclusive. It did not bridge the gap between internal committee views and legally operative title consequences. PW8 did not produce a vesting instrument, a reservation notice, or a title in favor of Kenya Railways. Her evidence, like PW7's, remained at the level of institutional process. PW9, Abdul Kadir Halif, was a surveyor and commissioner. The defense later relied on him as one of the technical professionals whose evidence did not support the investigating officer's public land conclusion. There was evidence that he did not remember attending a key meeting attributed to him. That uncertainty weakens the certainty with which the committee material can be treated. I find that PW9 did not materially strengthen the prosecution case on ownership.
We feel that justice has been done, although delayed for 8 years. We have been there. But I think the facts that we were always standing on have been proved. We have always said that we were following the law in performing our functions at the commission, and that nothing would be done against the law. So all procedures and laws were followed in ensuring that compensation for these 5 parcels was done according to law. So I don't know where somebody got this impression that those parcels were paid illegally and that they were not public land. I think the judge, the magistrate, has already proved that what we did was not wrong, and that we were right all along.